This presentation is about the Oklahoma Department of Human Services, DHS, and the new rule that they have regarding revocable trust. This is something that came out September 1st, 2016, that'll affect a lot of people that are, frankly, probably not quite ready for it. Let me go through what I'm going to tell you about is what the law is, what the new law is, and some strategies that you may use in order to keep Medicaid benefits going. And this presentation is relevant for both residents and their families, as well as nursing home facilities that are concerned about what this law will mean for them. Under the old law, if you had a revocable trust and applied for Medicaid, that was considered to be fine as long as the house was in the revocable trust. It was treated as exempt. So that was good news for as long as Oklahoma has had Medicaid. But there's been a change in the law. So what did this mean? So if you had a home in the revocable trust, it's not something that's known as a countable asset. Now, when you apply for Medicaid, there's things called countable assets and non-countable assets. Countable assets may disqualify an individual or a couple from having or from receiving or keeping Medicaid benefits depending upon how much the asset is. A home is an exempt asset when applying for Medicaid. And so ownership of a home would never create a problem for somebody who is applying and at least initially keeping Medicaid benefits going. The new law says that if the home is in a revocable trust, it will be considered a countable asset. So what happens now is on September 1st of this year, of 2016, the new rule was put into place. That's when the day the rules change is what we call it. So under the new law, a home, if it's owned inside a trust, will not be the same as individual ownership. What does that mean? It means that certain rules will come into play. So if a individual has a home, now what the law requires is that it be put back into the individual's name. If a couple owns a home, DHS will probably say you need to put it back in the name of the couples, which is probably a bad idea. But what happens now is for current recipients of Medicaid, the caseworker has an annual review. And the annual review, at the time of the annual review, well, I've got a little ahead of myself. So for couples, what does this mean? If it's left in a trust, it may have caused couples to have excess resources, resulting in disqualification. For individuals, that will almost certainly mean disqualification. This memo came out. Travis Smith is the deputy counsel for DHS, and this came out and kind of gave us, it was nice, it gave us a warning, but what it says is that effective September 1st, a home in a revocable trust is considered to be an available resource when a client's home, client being a Medicaid recipient, is in a revocable trust. The worker or the caseworker informs a client or his family or representative that the home exemption does not apply unless the property is removed from the revocable trust. It also says that when the client does not remove the property from the trust and the value exceeds a resource limit, the worker either denies or closes the SoonerCare, which is Oklahoma's Medicaid, closes their benefit. And it's requiring a 10-day notice. And it says usually the 10-day notice will be given when the individual case comes up for annual review. However, some workers may identify cases assigned to them and send the 10-day notice sooner. So it's the caseworker has to do this at least by the annual review. When you receive Medicaid benefits, there's a review once a year to make sure that you're still financially eligible. The caseworker can speed up that process if the caseworker identifies a home that's in a revocable trust. So let's talk about the 10-day notice. So it's 10 business days, what we understand from the reading. So you have somebody, or you are somebody who is receiving benefits under Medicaid. After the 10-day notice, if the house is not removed from the trust, then the benefits will cease, or is considered an accountable resource for an individual. That would certainly mean that the benefits would cease. Well, 10 days is not a lot of time if we're dealing with a family who a lot of times the resident is not the person taking care of the business at that point in time. It's either a child or a spouse, or maybe even a trust company that's doing this. And for them to respond within 10 days of receiving the notice is quite a Herculean task in order to get that completed. So it's a very short period of time. So what we are encouraging individuals and certainly facilities to do is try to identify these early. And once the 10 days has passed, at that point, if they exceed the resource limit, then the individuals will be removed from the Medicaid rolls as we understand them. This will be devastating both for the resident and for the facility. So for individuals, a deed from the trust to the individual really won't solve the problem. It's really a matter of going from the frying pan into the fire in these cases. The reason for that is an individual. Well, let me go ahead and run through this. For an individual, a home is exempt as long as there is an intent to return home. Now, of course, everyone has the intent to return home, and they can tell the caseworker, I plan on returning home no matter how sick I may appear to be now. But after 1 year as a nursing home resident, there's a presumption that the individual will never return to his home unless proof is provided that satisfies the caseworker that is really the intention. And the caseworker has discretion to give them 90 days to make that actually occur. So we're dealing with a caseworker reviewing a doctor's recommendation or authorization or plan for someone to go home, and a caseworker saying, yes, I agree, or no, I don't agree. So it's prudent on our side to say it's after a year, a caseworker is most likely not going to agree that the individual is going to return home. So what happens when the individual is really unlikely to return home? Then there's at the end of the 12-month period, the home becomes a countable resource. Okay, well, so what does that mean? Well, an individual that is allowed to have $2,000 worth of countable resources. It can be in the form of cash, excess vehicles, and other things. So a house that has more than $2,000 worth of equity in it will certainly cause them to become ineligible for Medicaid. So in layman's term, what that means is you're pretty much going to have to sell the house, and then you have cash, which is also a countable resource. Medicaid can also begin putting liens on the home property as well, unless there's some exemptions that apply. And if it's an individual with no spouse, those exemptions really don't exist. So now you have the house, and so it's very likely that the house will need to be sold. Well, what happens to the funds after the house is sold? Well, uh, the nursing home may think, well, this is wonderful because if they sell the house, now they can spend that money at the private pay rate until they're once again eligible, have $2,000 or less in cash, and so this might be really great for us. Of course, as a family member, you may be saying, why should I care? Won't the nursing home get all of the money anyway? If we go jump through all these hoops, we're going to lose everything, and there's really no benefit for us to do anything. So why should we care? Well, if the family doesn't act, there's consequences. And let's look at the consequences for the family first. Well, there's certainly a possibility of eviction if a individual's occupying a room and and the facility's not getting paid. They certainly have the right to seek eviction. There's certainly the stress of the uncertainty of your bill not being paid, receiving the bills each month showing a greater and greater amount that's owed. You may be facing creditor claims in probate or a potential loss, and you're certainly looking at the possibility of lawsuits for the services that they'll try to attach to the property. Not a great answer for the family. Certainly for the facility, they're looking at non-payment, the need for eviction, higher administrative costs, and problems with probate lawsuits, and dealing with certainly confused or angry family members. But there is some good news out there. The thing we got to look at here is a family might be looking, if we don't do anything, we get the whole pie, we'll get the whole house at the end. The nursing home may be looking at it from a different angle. If the house is sold, we'll be able to get all of that at private pay. But really, the reality is nobody ever gets the whole pie. So there's planning that we can do once the property is sold so that a substantial portion of the proceeds can be preserved for the family member. Yes, the house isn't there anymore. If the house were there, it'd be stacking up with liens from DHS. But what the good news is for the family is once the house is sold, there's some planning we can do with the funds so that a substantial portion of it can be preserved for the family members. It doesn't all have to go to the cost of care. You don't have to be private pay until all the money is gone. For the nursing home, the plan will, with planning, the resident will be private pay for many months. And if we have this in place, there won't be a lapse in the time that Medicaid is paying. And so they won't lose a client from being a paying client through the penalty, through a certain period, and then they would result back onto Medicaid pay. The real trick is, you have to know the rules and you have to know the moves. So there are certain techniques we do in the elder law that we take the funds and we basically split it. We can create a penalty period and with the same stroke cure the penalty period with Medicaid compliant annuities or Medicaid compliant promissory notes. So what we end up with is a situation where, with some teamwork, everybody benefits at least best from this bad situation. For couples, if the home is not conveyed, then well, let's talk about that for a second. DHS would probably tell the individuals, you need to convey it back to the husband and wife. Well, that's probably not the best answer. it should be conveyed to the spouse who is not in the facility, and there's some reasons for that. Failure to convey the property back out of the trust will trigger an analysis under what's called the Community Spouse Resource Allowance. This limits the amount that the well spouse will be able to retain, and it may exceed that amount if the house is not conveyed and the caseworker thinks the house is worth more than is allowed. So this may cause disqualification for the institutionalized or the sick spouse, as you may refer to them, may disqualify them from the Medicaid benefits. Well, if the house is conveyed, if the well spouse is still residing at the home, there's really not a problem. But what if the well spouse had moved out, maybe into assisted living or independent living facility? Or what happens if that well spouse later dies or themselves needs to go into a nursing facility? You could once again be faced with the loss of the home unless certain planning is done. So if a couple is looking at this situation, after the deed takes the property out of the revocable trust, the well spouse may consider some additional asset protection strategies and preserve the value of the home for the families. Well, what should nursing homes do? They're probably in the better position to be aware of what's going on. They certainly need to identify those who have homes in revocable trust if possible. This can be done by searching where the residents, their home county, and seeing how the property is titled with the county assessor. And that's certainly a good place to start. That's usually a free search that can be done. They need to start early so you're not dealing with a 10-day notice. You want to make sure that you identify the properties that may the residents have revocable trust that may trigger this 10-day notice. You certainly want to be well ahead of the curve so that you're not facing this and all of a sudden going into a non-payment status. Having the residents seek advice early so they know how to proceed is certainly a good tactic. They can certainly share this video with family members. They can have inserts that may remind those family members that there's this rule change that may impact the payment for the services they're receiving. Individuals certainly can seek counsel from an elder law attorney. This presentation was developed with attorney. I'm Richard Wimblott on the right-hand side of the screen. I'm an attorney in Oklahoma County, Edmond, Oklahoma. I deal with clients mostly on the western half of the state. And John Holden is an attorney up in Bartlesville. He works with counties with residents and nursing facilities that are in the northeastern quadrant of our state. Certainly giving us a call, letting us know what the situation is certainly a way that you can impact this. John's been in practice for, I believe, over 30 years. His contact information is there. I'm going to leave this screen up for quite a while, so people, if you want to write that down to contact us, you certainly can. But it's really important that you have the ability to recognize this early and to start planning early, because the worst thing that you could be facing is getting this 10-day notice, not being ready, and then having your benefits canceled as things were going fine, and all of a sudden everything changes. We certainly don't want to have that to happen. So I'm going to leave this up for a few minutes and finish out this video.